if I just scroll down this channel, I'm sure there's going to be many things that I can, extract from and comment on, and that would take a long period of time. Now, I'm not here to attack anybody because all of us have a purpose. Each of us are at a different level of awareness, okay, of our understanding what law is and what equity is, and where's this obligation that some people are looking to, and to which I've already discussed more than a few times. Now, the one I'm going to look at right now is this right here with Peace Officer Davey, and let me get into that a bit. So let me pause this for a minute, set it up, and we can start critiquing. Well, we have to critique, guys. We have to start investigating what we're talking about, because we're lost in these these connect the dot concepts where we come up with some sort of idea, and then we see how we're treated in court, and then we say we align that with how we're getting looked at or seen as within court, and then we're using a identifying point to make that explanation of why we're not being heard. And this is just one of those such things that we're going to get into when we're talking about, through the Vobes show, we talk to Peace Officer Davey.
Yeah, they don't know it's a trust. They think it's them, it's their identity. They think it's who they are, but it's not. It's completely separate to them. It's completely.
So is this is in the name that you call. So if you've called your
name, so
Joe
you,
Blogs.
for example, yeah. So if I said to you, introduce yourself to me. What's your name? What's your full name and title? What would you say?
I would say, well, I might say I'm Richard Vobes, YouTuber.
Right, exactly. So Richard Vobes doesn't exist in the realms of the living. There is.
Well, I mean, there again, see, now we've got truth mixed in through a descriptive view as opposed to an explanatory view. And I can say that because I watched bits and pieces of this. We never get into the explanatory view, to which I've uncovered or I've gone through to my English law series. And exclusively, I just went through in this previous video, I think it's video 63, when I'm discussing black belt barrister, and I'm also dealing with peacekeepers. Now, he asks or make a reference to the name, and we get back to ideas like Kate of Gaia and legal name fraud, and that the name's the issue, and so forth. But that again is never the issue. It's how we use the name, because the name is right, is a concept to which identifies us or relates us to a title, which is a estate title, not a living title. And he does explain that. He does say it's not the living. But the reason why I brought this in, because of how he then connects some dots that are not there. And this was a great point, or quite a great reference point to then help in us uncovering where is it when we then take an idea like life, and then we attach it to some sort of act, and then use that act without understanding what that act really is. So I'm going to go on with that, and I'm going to find the point where he's starting to, or he will connect some dots that are not even there. And by the way, there are many that connect the same dots as I connected those dots as I followed along way back in the days of the freedmen and sovereign movement.
Richard Vobes, okay?
Okay, now I'm actually ready to resume here. There was a little bit of a glitch. Let's see what else Peace Officer Davey has to tell us.
Of that trust, right? But the trouble is, right, because I'm not a trust, I'm a living being, they can't see me. They don't see me at all. Like, they don't see you. They don't see living beings.
Who's the they? Who's the they?
The they is the state, the Crown Corporation.
Right.
In the case of this country, it's the Crown Corporation. Excuse me. Yeah, so they don't see you. You become invisible because you are assumed to be under the Cestui Que Vie Act of 1666.
Bingo. There it is. It is the corporations, or the crown corporations, if we understand what Peace Officer Davey is saying, is a result, or they don't see you as living. And the reason why they don't see you as living is because of the introduction of the Cestui Que Act of 1666. So now that's all we need to know of where he is coming from. Okay, he's connected those two dots. And that's what his whole program is. He's going to explain how that all works. Okay? As we've already come to our knowledge, and by either A, reading some of Blackstone's and all those different links I provide with my videos, or your own research, or you've watched some of my English law series, we know that is a fallacy. So we can get rid of that. And what we're going to, this whole point of this video is to now nip that in the bud, and so that we're no longer making that connection between the Cestui Que Vie Act 1666 and how the Crown Corporation sees us. As to give you a quick overview, we already know that the system, right from the English law, at the beginning of English law and its evolution, does not deal with live beings. Okay, it deals with rights to land, to which then someone comes in and says, I want to then control that right. Well, first of all, you have to have the correct status, and then once you have the correct status, then you were given a tenure, which created an obligation. That was how the system evolved and where it came from. Those in equity, the Roman Church, the Jewry and stuff like that, only came in through the beneficial use of the fruits of that land that came from the land, and that's what they had an interest in. They didn't have an interest, or could ever hold an interest, in the English common law, because they are perpetuity instruments, and you needed a life interest in order to establish that allegiance with the monarchy. It was based on honor, chivalry, grace, and all of that kind of stuff. All the nice little things you heard back in, the knights and their grace and chivalry, and how they conducted themselves in honor. Okay, now what has happened through the freedom movement and the sovereign movement to then come across this concept of originating from the Cestui Que Vie Act is that never can the court, or is there ever the courts in equity ever even thinking about you living, because that is not the issue, as we've already established. We're not discussing whether you're alive, because that's a moot point. Okay? That is, it doesn't even need to be conceptualized within the court, because that is not what they're looking to. They're just looking to the agreement. That's all they can look to. They cannot look to who you are as a live human being and the rights you have there, because that is something as a different subject matter than what the courts can handle, who are in equity, as they only deal with those interests that are beneficial, and they are noticed through an agreement, through an act of parties. Not an operation of law, but an act of parties. That is how the system looks too. And it doesn't, again, it only looks to the agreement, not whether you're breathing, living, and above ground. Okay? So, right off the get-go, you can see that if that's the case, then all of this is a moot point. Okay? It's just rhetoric. It's just discussing ideas and concepts of how we arrived to where we're at today. But I'm going to even dissect that a little bit further. Okay? I should have had it ready, and I wonder if I can get it quickly up. I'm using a different computer here. Well, what I can do, I can pause this and get back and find it. All right, we're back. Okay. The Cestui Que Vie Act, 1666. We can see the introduction, and let's just go through introduction to see what this act is actually speaking to. Who are the parties of interest within this act? Now, we got at the very onslaught the introduction that it's an act for redress for inconveniences by a want of proof of the deceases of persons beyond the seas, or abstaining themselves upon whose lives estates do depend. Now, as we go in through this, we go into, whereas diverse lords of manors and others have granted estates by lease for one or more live or lives, or else for years determinable upon one or more life or lives, and it hath often happened that such person or persons for whose life or lives such estates have been granted have gone beyond the seas or so absent themselves for many years that the leasers and the reversioners cannot find out whether such person or persons be alive or dead, by reason whereof blah 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 blah. That is what we need to know. Okay, so maybe dissect that and then think about when people start using this act as a means to stand upon and say, hey, I'm a living man or a woman, and thereby I now, using this act, want full redress and full return of all my assets. Okay, that's what this whole idea, concept of free man sovereign movement's all about, is trying to get redress for those estates that they hold and have a right to when they are now proven alive. I hope I nibbed that in the bud. We're not proving we're alive. It doesn't matter in law. That's not what we're dealing with, but let's go into what they're dealing with here. Okay? They're speaking that recital of the Cestui Que Vie have gone beyond the sea, and that the reversioners cannot find out. Who's the reversioners? Who are they? Reversioners are those who hold the legal estate, the superior title to which they carved out an equitable use from, which is a lesser estate or a smaller estate, to which tenants then of these rights to a lesser estate have gone beyond the seas, and while there is that tenant has a right of possession, so it's a different title altogether, and the reversioner has a right of ownership, or season as we like to call it, or as we have learned through the English law series, there's liberty of season, which was a enactment that had to be done in the now, and it was through a ritual of passing on, like a rock or a boulder or a staff or something, from the land to represent the land, to then pass it on to anyone, so someone else who would be the grantee, you're the grantor, that person who held the land then gives it the grantee through witnesses, and the witnesses now verify that that new individual that's holding that rock or that piece of turf or whatever they're holding that represents the land is the new owner. No longer are they the grantee, they now are themselves the grantor, and that means the whole entire state passed over. There's nothing left over. It's all passed over to that new party, and thereby the previous grantor who held the land interest or that estate at that time, that legal estate, has no more interest in it. It's done. It's cut and dry. Okay? So, if you're claiming under this act, means you've already subjugated yourself to a lesser estate, because it is that which is due to the reversioner, whereby the tenant is missing, and they put a limitation of 7 years. Why? Because the tenant held possession and the reversioners held out of possession because they didn't have that title. They gave a lesser estate called the possessions estate to the tenant, who now has a right. Just like we have landlord and tenant agreements today. They have a possessory interest, but they don't have an ownership interest. And then, as well as the possessory interest is not the same as the owner, and neither the interest of that legal title, nor can they intermix. No matter what happens, one is one title and the other is the other title. And possessory has certain rights as a tenant to hold that interest against the landlord, and vice versa. But they're put together. They're not melded because they're still two separate estates no matter how long it goes on ad infinitum. If that landlord keeps on passing on his inheritance and that legal title, and then the tenant with the right to pass on its inheritance, that title, they remain separate. They are not the same interest, but what grinds them together, what melds these people, these parties together, is an act of parties to whereby now that agreement that's created that gives certain rights to the possessor, and the rights to the owner, that agreement is now the interest that both parties have a right to create rules of action against or petition against if they are wronged. And then that is what they bring to the court. The court doesn't care about whether you're living or dead or what it is, that it's only interest, what the parties have brought in their respective statuses according to that agreement to the court, and then the court only looks at that agreement. It's not looking to the land ownership or the legal estate title, and it's not looking to the title or the equitable title that the tenant has. It's looking to the agreement that both have created as a result of that interaction. And we could even go from here. And the estates are dead in regard that the leaser and reversioners, when they have brought actions for recovery of their tenements, have been put upon it to prove the death of the tenants. So, if you're saying, I'm dead, I'm lost at sea, I'm going to use this act, you know what you're saying? I'm a tenant. Do you see what you just did there? And this is the same thing, back to that obligation again. You're just saying it by your very own actions that you're the tenant and you have a right to that estate, and you're going to now exercise your right over the agreement to hold that estate against those who have a separate interest. You're creating the obligation. It can't get any more simple than that. You're doing it. That's the obligation. It's what you're holding and how you're fighting it. And if you come in here and you say, I'm man, you lost. I'm coming in with a common law interest. Well, what common law are you speaking to? You're looking to the original legal estate that's held in the monarchy, or you're looking to the common law of the territory? To which then you're coming in as, I want equity so that I can be heard. Which, here's an idea how we can distinguish those two principles when equity overreaches the common law, which again has to be the same subject matter. So it's the tenant subject matter that's the law, to which then equity is the predominant court that looks at it, and that's why equity prevails over that law. So let's just say, for instance, let's give a scenario. You have a joint title of an interest in property under government, and you have a legal estate under government, which is the third level use to land as an assumed owner. And you then rent that out and you have a tenancy agreement. Okay, so now you have an agreement, and that's what you're always going to rely on, is that agreement now. Now, in that agreement, it says that you owe so much rent. Okay? And then the tenant doesn't pay the rent on the specific times, or fails to pay for rent for months on. Okay? Now, through that agreement, the landlord is going to have the ability to now exercise his right to recover the rent or recover possession. He has to make that choice, recover the rent or recover possession. He goes to the agreement, to the common law agreement. That's what we're speaking about as in what would be the common law. And then if you went with just that right, it's right there in the agreement. The court would the judge would rule in the favor of the landlord and say, yeah, you didn't fulfill the agreement. Okay, but that's black and white. That would be common law in that matter. But there might be some mitigating factors, other things that are not considered yet, to which that's when equity comes in. So let's say, well, the reason why the tenant wasn't paying the rent is because the landlord was to fix the hot water tank, and there was the house the heating, there was no heating in the house, and he said on his agreement that he was going to come in, and since he wasn't doing that, you took money as a tenant out of your own pocket and you got those things fixed. So that's why you weren't paying rent. Now, what does the court look to? It looks to make sure that everything's equal. Both parties are being honoring both of that original agreement, to which then, if other circumstances arise from the agreement, that then would show that, hey, you know what, the tenant is right in this time as this right. I want to give the award to the tenant because the landlord did not do what he was doing. That is when equity would prevail. Okay? That is when we use that concept. But again, when we're using the concepts of equity always prevails over law, English common law, absolutely not. For the simple fact that the same reasoning that if you were dealing exclusively to the equitable interest or legal title that's held of the one who's got possession, and the ownership title to the one that has the legal title, which is seisin, those would never commingle, because never can the one who has possession ever take control of that legal title. Ever. Only the landlord, or the one who has seisin, can take over the possessory title, but through conditions already created within the agreement, to which, there you are, the law is not looking to either title at this point. That's not the issue. They're looking to the agreement. So, nip this in the bud. All of you can now get rid of the Cestui Que Vie Act of 1666 that you're dead at lost at sea, and you want to come in and use that, and that's why you're dead, and you need to prove that you're alive. Okay? It's like the black belt barrister said, it is a waste of time for the reasons I've already just expressed. And obviously, if you use this, that means you've just given your right as reversionary to legal estate to become what? Thank you, and God bless.